Good afternoon. This is Tim Fry, an associate in the healthcare group at McGuire-Woods, and thank you for joining us today for a fireside chat, a fall-themed turning over every leaf in regards to Stark Law compensation changes that are coming effective January 1st, 2022 for physician group practices. We thought as we headed into the fall, and I make lots of bad dad leaf and fall jokes, that it would be a great time to connect with all of you who are with us and our clients to kind of make sure everyone is aware of what's happening, the changes, and then talk about how that might impact different groups so you can think about whether or not you need to look at things this fall before the new year. For those that haven't joined us, McGuire-Woods before, we're a large national law firm, offices across the country. Gretchen, who will be introduced in just a minute, and myself, Tim Fry, are both out of our Chicago office, do a lot of work on physician practices as well as investors in the physician space. Prior to law school, I worked as a staffer at the Centers for Medicare and Medicaid Services, and so their very zombie-like bill, the Stark Law, ends up being near and dear to my heart. I'm joined by my amazing colleague, mentor, Michigan State football fan extraordinaire, Gretchen Townshend, partner here at McGuire-Woods, and is, in the midst of some construction projects, so she's actually relocated today so that her sound quality is strong and hopefully we can hear everything. We have to put a legal disclaimer form up. You can read it if you'd like to. The key here, as we talk and set the agenda, is we haven't formed an attorney-client relationship while we share these thoughts this afternoon. And if you would like to talk about any of this, we'd be happy to offline. In terms of an agenda, we're going to just make sure everyone knows what I'm talking about when I say the Stark Law and group practice. Talk about that definition. Then we'll actually share in one slide why and what CMS did that brought us together. We'll go through some hypos so you can see how this small change could impact group compensation structures. We'll wrap up at the end with questions and a few other things that have been changing with respect to the Stark Law. With that, Gretchen, would you like to kick us off and share kind of some of the background and basics here that folks should be aware of?
Absolutely, and thanks everybody for joining us. I do want to highlight for you that we do have a Q&A function on the presentation. So if you have questions as we're going through, please don't hesitate to type them in, and we will try to address them during the course of the presentation at the end, or can follow up with you after the presentation is over. So let's set the stage. I am going to start with the background on the Stark Law. Many of you are probably relatively familiar with it, but it certainly does set the stage for what we're talking about today. Essentially, the Stark Law prohibits physicians from making a referral of certain types of services, or DHS, we'll talk in a minute about what is included in DHS, to an entity of any kind, a hospital, a lab, and their own group practice, importantly, which that physician has a financial relationship with, unless a specific exception applies. So it is a strict liability statute. The referral is prohibited. Billing for the claim is prohibited unless that financial relationship or the referral is protected by one of the enumerated Stark Law exceptions. Historically, we've had 38 very highly technical exceptions to utilize to protect various financial relationships. Things like the lease exception, things like an employment exception, and the In-Office Ancillary Services Exception, which we'll talk about here, which often protects referrals within a group practice. But they are very nuanced and specific as to what you need to do in order to comply with those particular exceptions. if I were on video, you would see me holding up multiple volumes of thousands of pages that we have compiled here at McGuire Woods that includes all of the guidance that is out there from the government on the physician self-referral law, the Stark law. One might think that the application of these exceptions would be fairly straightforward, but one would be wrong in that thought. It is incredibly nuanced, and frankly, we frequently find that arrangements don't squarely or clearly fit an exception, not because anybody is trying to do anything improper or inappropriate, but the nuance, there is a trip over some of the nuanced rules there. So we're often left doing some funky twists and turns in order to make the best arguments we can to support that the financial relationship between the DHS entity and the physician is not improper under Stark. So while normally the discussion of Stark, when you all have to talk to us lawyers about Stark, it can be a little deflating or depressing in some ways, there is some good news in the Stark world. In late last year, effective at the beginning of 2021, CMS did make several changes to many of the provisions of the Stark law, which in totality generally made compliance with this law easier. We're not going to go into all of those changes. That's not what the focus of this particular talk is. However, I can point you to the McGuire Woods website where we have summarized these changes if you're interested, and certainly happy to talk to you about those more fully. We may give a few little highlights at the end if we have some time. But at the end of the day, compliance with this law has become easier in most circumstances. However, what we're going to talk about today with regards to the group practice changes and the way in which compensation has to be divvied out, the clarification made by CMS in this regard is one of the few instances where what you are doing today, the status quo, could be arguably fine today and no longer fine once the rules change in January of next year, which is why we are so glad that you have joined us. So jumping back, what is DHS? So what are the services that we're talking about for which Stark applies? It is not all referrals, importantly, unlike the anti-kickback statute, which many of you are probably familiar with. This statute applies to the referrals of certain limited types of services. And they're all listed on this slide, but for purposes of group practice, the first 7 or 8 are the most commonly done within the group practice. Clinical lab, PT and OT, excuse me, radiology services, radiation therapy, some limited DME, prosthetics, orthotics, etc. And so the concept generally is if a group practice is providing these services and their physicians who work in that group are referring patients for these services within the group practice, Stark applies, and the group needs to meet the definition of group practice, which we will talk about in a moment, and that includes the way in which those physicians are compensated, which is really the thrust of the change. So what, right? Okay, we know the rules, so what? What if we refer and bill the DHS anyway? Let's say we don't actually meet an exception, and the group practice in this case bills for the DHS. What does that mean? Well, the group has violated the law, as has the physician. As I mentioned earlier, this is a strict liability statute. There is no intent component to what is being done. You either meet the exception or you don't, and if you don't, you're toast, unfortunately. The basic penalties for Stark are financial. This is not a criminal statute, so that's also, I guess, some good news. But the financial penalties can be fairly significant. So not only does it include the refund of the claim, the improper claim for the DHS that was submitted, there are penalties, which can be not only 3 times the level of the claim, but also additional per claim penalties that can apply, as well as additional civil monetary penalties and the potential for exclusion from the Medicare and Medicaid and any other federal healthcare programs. It can also, as noted here, form the basis under the False Claims Act. So it has the potential, an inadvertent violation of Stark has the potential to steamroll into something much bigger than anybody would want or expect. However, there is a self-referral protocol, so if there is an inadvertent trip over some of these rules, there is a process by which a provider or group practice can raise their hand, say, whoops, we messed this up, and go through a alternative settlement process which can reflect significantly less damages. If you look at the bottom of the slide, this is, it may be a little bit hard to see, but this is the financial implication of what it could potentially mean to violate Stark. In this particular example, you've got $75,000 of Medicare collections for, let's say, lab services, reimbursed at $100 a pop, 750 labs. So, okay, that's refunding Medicare $75,000. Penalty could be times 3, so $225,000 for the actual claims, plus the per claim potential liability, which at its minimum could extrapolate out to in excess of 11 million, at its maximum could extrapolate out to excess of 22 million, which is why the self-disclosure protocol, which we'll talk about briefly at the end, is a good method to raise your hand and admit fault. So those penalties are, government comes after you, you've done some wrong things, you know you've done some wrong things and you haven't taken appropriate action to cure those items and report them. Similar good news with the self-disclosure protocol is that often those claims are settled for, you know, less than 10 cents on the dollar. You don't have the excess penalties, et cetera. So your exposure through the self-disclosure protocol is in all cases going to be significantly less than it would be if the government came knocking and finding out these issues. The other component to keep in mind is that this can be the basis for key TAM actions or other similar private parties bringing claims to the government, which the government then prosecutes, triggering those significant penalties that I mentioned. So that's, with that, I'm going to turn it back to Tim, who's going to focus in a little bit more on group practice within that framework of Stark overall.
Thank you, Gretchen. And so let's start shifting towards the group practice, because that gets significant protection under the Stark law. And we all sort of think we know what a group practice is. Certainly I would have before I became a lawyer, colloquially, the doctor's office. You know, when there's multiple physicians involved, we have a group practice. And that might be right, but CMS has also had to struggle with, what about university faculty plans? What about hospital systems and their medical staffs when they're employed? What about urgent care centers? And so you may think you know what it is. You may, in this picture that is on your slide, think you see 5 ducks. They quack like them, they waddle like them, they look like them. And the question CMS is going to ask, and we're going to be talking about today, is it actually a platypus? And that's what this group practice definition is driving at. We think in terms of 8 questions. It's actually 9 paragraphs of the regulation. You have to be things like a single legal entity. You need to have more than one owner or employee physician. Those members need to be providing their full range of care. They need to be doing it through the group. They can't do sleep studies with our group and then go off and be a neurosurgeon with another group. We force a lot of things together. And the first 7 on here are all consistent with the history of this law, no changes. But it's this compensation question, proper compensation, which is, it had an adjustment and a change. And this is important because to use, as Gretchen pointed out, the In-Office Ancillary Services Exception, one of the, if not the most common exception for group practices. It allows you to do services within your group, those DHS items that Gretchen noted. You're able to run labs, you're allowed to do x-rays. You use that very technical in-office ancillary services exception, which we'll talk about at the very end more in detail. You have to be a group. And to be a group, you have to meet the definition. And to meet the definition, you have to pay appropriately. And so if you don't pay appropriately, then you are not a group practice, you are a platypus, and you're not allowed to use this very flexible and important exception. So what changed? And on this screen, you have kind of the new rule as well as kind of a comparison to the old rule of the language, but I'm not going to make you parse all of it. In fact, I'm going to just highlight the change that CMS made. And that, quite honestly, the big one is what's in orange here, that the profits that are going to be shared in compensation have to be derived from all of the designated health services of any component of the group with at least 5 physicians or the entire group. So let me take a step back and just kind of set this, what seems like a small change, that insertion of all, and then explain why it's bigger than it looks, at least for many groups. And then we'll go through some hypos so you can see how it applies. To compensate physicians appropriately, CMS was trying to balance the statutory mandate that physicians do not receive payment for their referrals with the fact that group practices do designated health services, and that money has to go somewhere. Usually it would go to the owners, but not always. Maybe you want to pay the employees for the work they're doing. So they allow productivity bonuses that can pay someone for doing designated health services. Your radiologist can be paid for doing the x-ray read. Your pathologist can get paid for doing reads on laboratory services. Designated health services, but things that you're allowed to pay directly for that service being done. Even after that's the case, you may still have profit. So you're allowed productivity bonuses. You're also allowed profit shares. And they've always had this concept that you don't have to share it among the whole group, especially for large multi-specialty group or large groups with many locations. They've often taken advantage of this, what we often call a pod or a pool concept with 5 or more physicians. So you might put 5 specialists into a pool together to split their DHS profit differently than you do a different specialty or different location. Or for, investor-backed platforms, they'll often bring practices together, start operating as one practice, but they'll keep some of the historic compensation in place. Well, that's what they've been using, this 5 or more concept. But some groups would go beyond that, and this would go to the hypo and said, okay, we'll do 5 or more physicians for lab. We'll do different 5 or more physicians for x-ray. And what CMS kind of spoke very clearly in its rulemaking and then this insertion, their intent is not to allow that kind of service by service separation or kind of pod overlap of different physicians. They really want to see all of the profit from the designated health services, whatever the ancillary line is, aggregate it, pool it, then figure out how you're going to share it within the group. And they wanted to give some time for you to adjust that prospectively, and that's why we have the January 1st date. Now that change is nuanced and we scheduled an hour webinar to talk about a small change in a paragraph. And many of you may be saying, okay, how is this going to impact us? Does it impact us? Maybe it doesn't. And instead of me just spending time on this paragraph or pulling out other commentary, what Gretchen and I thought would be most helpful is to give you 5 examples, 5 hypotheticals of different fact patterns, and I'm going to turn it over to Gretchen to talk about the first, so that you could kind of see how that small insertion may or may not impact your business, your practice, your investments.
Thanks. And I think before jumping into the hypo, one thing to keep in mind that, this feels prescriptive. It feels like it's narrowing. It feels like CMS is potentially making things difficult for physician practices, and we certainly hear and feel that sentiment from our clients. It is important to note that, of course, a hospital could never pay a physician group for each x-ray they refer. They could never pay a physician group for each surgery that they perform at the center. So I think it is important to think about the ability to share these DHS profits within a group practice and provide some flexibility. CMS that's what this exception and the definition of a group practice is for, but they do put parameters around it so that there is not a situation where each physician who orders a lab, each physician who orders an x-ray gets the financial benefit of those dollars. Whether or not we agree with whether or not SARC should be in place, that's the thinking. And this pod model that Tim mentioned and the theme behind this aggregation of the DHS is really intended to create further separation between the referring physician and his or her independent referral. Pulling everything together, requiring at least 5 physicians to come together, kind of making the dollars more of a collective, help separate you get paid per referral, which incentivizes you to make referrals that the government would ultimately deem to be unnecessary potentially. So just wanted to kind of give that framework for why this change and this clarification was ultimately necessary. Okay, jumping into practical patterns. Number 1, multi-specialty group practice, and to be clear, these are compensation models we have seen, right? These are not things that are created. We've seen, we tell clients all the time, you've seen one compensation model, you've seen one. Everybody has their own variation on different things, but each of these are things we have seen in practice, so they may or may not mirror some of what you're doing. Hypothetical 1 is for a multi-specialty physician practice that has both lab services and x-ray. Everyone within the group utilizes the lab, and so the group has historically shared those lab profits equally across all of the physician owners, regardless of their specialty. The group practice also, though, has x-ray services that are utilized by only certain of the physicians in the group. And so they want to and they think that it is more appropriate to share that x-ray profit based on how productive physicians are. So labs, for example, evenly split, doesn't matter. Part-time folks get the same as full-time folks, et cetera. But the x-ray they wanted to do a little bit differently and allow the higher producing, the busier physicians who are working more hours and seeing more patients to receive more x-ray profit. And so that profit was distributed based on work RVUs. The folks with the most work RVUs got more of the x-ray than the folks who did less. As a quick point of clarification, either the per capita split or the split of DHS based on personal productivity are appropriate methods. Either of those things are perfectly fine under CMS rules. So either one could be okay. but is it appropriate for them to have two different methodologies based on the service provided? Can they do this anymore? No. You now have to, as Tim mentioned, pool all of the DHS first. So the lab dollars and the x-ray dollars need to flow into a single pool, and then that pool needs to be split one way. It can either be per capita or it can be based on personal production, but because the pooling has to occur first, you cannot use two different methodologies for two different services.
So that takes us and
nope, go ahead.
I apologize. I already previewed. I'm going to go back. I'm sorry about that. If we only make one double-click foot fault, I'm going to consider it a win, Gretchen, but we're only halfway through, so that might not be true. So our second hypothetical, we have an ophthalmology group who had spent time thinking through certain things, thinking through the Stark rules, and one of the things they thought through was imaging, technical component imaging, and for those of you that have had vision tests before or maybe are on the line in that space, a lot of imaging is done to kind of look at the retina and look at the eyes and make sure people's vision are in way, and some of that is designated health services. And the technical piece is a referral. It has typically been seen as a referral because the doctor is not personally doing it. Instead, you usually would have a technician help with the image tests, and therefore, under Stark parlance, the technical piece would be a referral. So to avoid concerns under these complicated rules, what the group has historically done is pulled that technical component imaging revenue out of their plan and used it for other purposes. Paid for the technician, paid for the machines, but also other practice overhead. And then they only pooled retina drug injections, and a pool is set up. And could this continue? And if I didn't click fast enough earlier, you may have already seen this. Probably not, although we're going to use the word likely. There's maybe some facts that could figure it out, because the idea is you have to pool all profit. Now, I think there is a question here in the way we set this hypo up, is maybe the cost to the practice and therefore the estimate around technical component means that it would work. CMS is not so prescriptive to say you have to keep separate P&L statements for every ancillary line. You do not have to have your accounting firm audit and use some type of GAAP standard to figure out, whether or not you meet kind of this standard and meet this level of profit. But you're going to have to be reasonable. And so then the question would be, and the facts that you'd want to develop if you wanted to continue this methodology is, hey, can we defend backing out all of the technical component revenue? Is that a cost we can represent to say that we don't have profit on the technical component imaging? If you cannot, you sort of have this odd impact where CMS, in trying to prescriptively put rules in place to avoid different types of pooling, to reduce incentives for referrals, in this situation is kind of saying, no, you have to add more money into your pool, and therefore maybe the incentive would go up. So there are some odd answers that come out of this change, and this is one, and why we kind of dreamed up the hypo a little bit with things we know. And so I'm going to click to slide 3 and let Gretchen take over the next hypothetical.
Okay, hypothetical 3. This is a little bit similar to 1, although a slightly different fact pattern. Here we have a very large orthopedic group. We'll call them 40 doctors, and they do all sorts of ancillaries within that group. Historically, and then they're at multiple locations. They got lots of locations, and they have many different ancillaries. Some of those ancillaries are located within their locations, like an X-ray and the MRI. Some are located more centrally. For example, physical therapy. They've got a physical therapy arm. Those are centrally located, and the orthopedics from all over the group practice refer to the PT. And the physicians working in a particular location utilize the radiology and imaging in their own locations. And in some cases, they have DME and more often prosthetics and orthotics that are provided with physicians, by the physicians in their location. So historically, they've taken those ancillaries and treated each one slightly different with different groups of folks. So they have the individuals who work in the locations, at least 5 always, because they knew that they had to comply with that, split the MRI and imaging amongst the 5 physicians who were at that location utilizing that piece of MRI. The DME POS was shared by the physicians that actually provided those items. So there were maybe 2 physicians at each of their 5 locations who provided those services. So they pooled the DME-POS and put that all in one pool and distributed it equally amongst those 10 physicians. And then finally, the unified physical therapy locations, those were separated based on at least 5 physicians who are closest to the PT. Again, thinking that these are the physicians who utilize these services. We are maintaining our groups of 5, and we are putting them with physicians who in different groups. Importantly, each of these services were distributed per capita. So each were pooled separately, but were all distributed in the same way. It's just different groups of physicians share in different pieces. Can this continue? You probably know the answer based on what we've told you. No, it cannot. Unlike the first one where we were talking about the pooling being different and the pooling being of the same physicians, but the distribution being different, here we're talking about the pooling being separate, even though the distribution is the same. But here we can't. Again, we need to have a single pool that has all DHS flowing into it for a group of at least 5 physicians, and then each physician can only participate in one pool. So don't necessarily have to combine all of these things into a single pool shared by all 40. But if you're going to break them into groups of physicians who can share in this DHS profit pool, then the dollars from all 10 of those physicians in all of the different DHS service lines have to flow into that pool. I'm going to flip to hypothetical 4 and turn it back to Tim.
See, we can learn and avoid tripping a second time. So this is great. So now we have a slightly different example, infusion centers, and just very similar, large group. Gretchen used 40, let's go with 30, and they have multiple centers. Each center has at least 5 physicians. They've been historically and would plan to continue doing a separate pool at each of their locations, again, 5 or more at each. But each center, each location of the group kind of used a different methodology. One did it based on production, one was pro rata, one was based on height. I'm sure they didn't do it that way, but you know, the point being, they came up with methodologies, but each location, each center, each care center did a different way. It seems like with what we're telling, a lot of things need to be kind of revised. Does this need to be revised? And based on what we dreamed up, the answer here is it wouldn't need to be revised. It can continue. The key change is not CMS micromanaging to the level of saying everyone has to do things the same. It's you need to kind of treat your groups, your pods, collective, each one kind of together and not kind of get to that either service line or overlap of pods. And so here, that's okay. Location 1 can continue to do pro rata. Location 2 can continue to do it based on kind of production and an appropriate profit share split. So if they are following some of the appropriate profit sharing rules, it does not have to be the same across the organization. That can continue, and they can kind of continue to do things slightly differently. And so that it's not, even though we're going to mainly go with hypotheticals and show you hypotheticals of places it's going to change, not every group practice that we work with or across the country, not every group practice is going to need to make any change before January 1st. And here's an example of one. It's okay that they're using different methodologies as long as they first pool all 5 and bring them together.
Last hypothetical here relates to, again, an orthopedic group that has ownership through the group practice in 3 different ambulatory surgery centers. Historically, some doctors only provide services at 1 of the 3. Some, like Dr. Green, provide services at 2, and some at 2 of the 3, and some, like Dr. Black, provide services at all 3 of these surgery centers. Historically, the group has distributed those ASC distributions to the physicians who use the center. So the Cider ASC will distribute it to its 5 physicians, Indigo, Green, Black, Garcia, and Miller. They all share equally in the distributions from ASC Cider, and similarly for the other 2. As you can see, certain of the physicians participate from multiple ASCs, so they get distributions because they utilize more than one. Can this continue? The answer here is probably yes. It's a bit of a trick question because surgery centers are not, and ambulatory surgery centers and services performed there are not DHS. So everything that we've been talking about here does not apply to the distribution of surgery center profits from a surgery center to physicians or to a group, and then from the group to its individual physicians. However, we wouldn't necessarily want to rubber stamp this as fine. There are other statutory bodies out there that may, state law and the anti-kickback statute, that need to be complied with, and making sure that this type of a distribution doesn't run afoul of any of those rules either. And so there are other considerations here, but at least as far as these stark changes are concerned, the distribution of non-DHS revenue outside of a group practice does not necessarily need to be changed in order to avoid stark law liability.
So I think you got a sense of this. The profit sharing rules have always been complex. This small change, really the addition of the word all, and then their backup behind it, their rationale in their regulations of why they made the change, speak to everything we just talked about. But we wanted to show you, this is kind of the flow chart. We end up going through with clients when we're talking about compensation, and the items in the yellow on the right and in the things in orange towards the middle are kind of safe harbors or places where CMS has specifically said it's okay, like paying, WRVU bonuses as a production bonus. It's probably going to be fine. Taking all of the DHS profit of the group and just splitting it pro rata, going to be fine, going to meet, and it's going to go to our Maple Leaf, and it's going to be Stark Law compliant. But it takes some steps to get there, and then there are places where we end up in kind of an orange or red zone of saying, hey, we need to look at this more carefully. And those are some of the places that, you know, you all might want to think about. But the real change here is just simply kind of that all. So this question 4 in our structure, before, the argument could always be made that DHS profit share, yes, did it comply or not for each service line? Now it needs to be all. And that's the change, that it had always been complex. We're focusing on the change. It's always fun to talk about changes in law, at least it is for lawyers. Thank you for humoring us today. But you don't just have to keep the changes in mind. Everything that has applied with the Stark Law in the past is still the case when we're talking about groups, and that's especially the case for the exception that we had talked about a few times earlier, the In-Office Ancillary Services Exception. And for groups, in addition to meeting that group definition that was on your screen earlier, you also have to meet 3 tests. It needs to be supervised by a referring physician, another member of the group, or someone supervised by a member of the group. It needs to be taking place either in a centralized building, which is a space, not necessarily the whole building, but a space within the building that the group has exclusive control over, not a timeshare, not a part-time arrangement, but a space that is used exclusively, or is in a building or space where the group regularly performs other services, sees patients that are not DHS. And this 2A that's on your screen is an entire separate couple hours we could spend and go through all those rules, so we're not going to do that. Just know that it's basically asking, is this a place the group does non-DHS? And there are all kinds of subparts to figuring that out. And then the final test that always needs to be kept in mind and read in parallel with the group practice is that it needs to be billed by the physician who did the work, by the group practice, an entity owned by the group practice wholly, or a third-party billing agent and of the group practice. So again, CMS is really trying to drive at, hey, is this happening as part of a group, as part of a situation where people are practicing together and providing the services in the natural flow of patient care?
So now we've been through that, the change, the basic rules and the changes, a couple additional items that we wanted to highlight here. As I mentioned at the very beginning, there were a number of changes to the Stark Law that provided additional flexibility with how compensation arrangements can be structured. One of those were a new set of value-based enterprise exceptions. And these exceptions were intended to provide more flexibility to allow more direct compensation for physicians and DHS entities when they are participants in what is called a value-based enterprise. What a value-based enterprise is a venture, if you will, of these parties with at least two participants that has a value-based purpose. And the value-based purpose are things like care coordination, improved quality, reduction in cost, transition to pay for performance rather than fee for service. And CMS has, and OIG both, because there are value-based enterprise safe harbors as well to the anti-kickback statute, again, beyond the scope of this discussion. But essentially, CMS wanted to give a little bit more flexibility to financial arrangements between DHS entities and physicians when they are working together to try to emphasize or achieve one of these value-based purposes. the exceptions, there's 3 of them, and depending on the level of risk that the physicians have with regards to the enterprise is directly proportionate to the number of restrictions and rules needed to comply with that exception. So if, for example, it is a full risk type of an arrangement with full capitation, for example, there is quite a bit of flexibility with the participants in the enterprise to share the DHS revenue. If, for example, the physicians don't have any downside risk, but they get upside risk in a particular arrangement, then there are a lot more rules and hoops to jump through in order for the value-based enterprise to comply with the new exception. Again, like what Tim mentioned before, we could spend 2 hours talking about these exceptions. And frankly, it's not entirely clear the extent to which these would be utilized in a group practice context, because the In-Office Ancillary Services exception that we just discussed does provide quite a bit more flexibility than compensation arrangements with, for example, a hospital and physicians. However, if these exceptions do need to be kept in mind when groups are looking at these value-based enterprises, their participation in them, and how the dollars from those enterprises can be distributed to their physicians. One real-life example is gain sharing. It used to be very difficult to defend gain sharing under the Stark Law in a way that would compensate a particular physician for the quantity of savings he or she generates by his or her surgical services at a hospital, for example. The old Stark laws made that compliance there difficult and had to be creative with how those gain sharing arrangements looked. Well, now there is more flexibility, and not that you don't have to jump through a bunch of hoops to comply with an exception, but gain sharing is something that was specifically mentioned as a business objective that could be protected by these exceptions. And so if, for example, a group practice is part of a gain sharing arrangement with a hospital where the group gets paid based on cost savings generated by its physicians, it is likely possible that that group can then pass those savings on to the physicians individually who generate the savings. At least there is a much more ability for them to do that today than there was a year ago, because we have these exceptions that are available to protect those kinds of relationships if, as we always say in Starkland, we meet each of the elements and requirements of those exceptions. So again, not something we need to go into great detail on, but something to keep in mind within the group as group practices are looking at these value-based enterprises and the ways in which they are aligning with other providers in the spectrum of care, and how when they are working together to achieve one of these value-based purposes, there is now enhanced flexibility in how those dollars are distributed.
So act now. Come on down, kind of. Was that an okay voice, hopefully? Try to get a little enjoyment for y'all this afternoon and not be too used car salesman-y. But the regulations taking effect January 1st, we certainly encourage you to look at your plan. Make sure, what you're hearing here today, you think you're comfortable with how you're doing profit sharing or production bonuses, and make sure you have some comfort there. We are certainly talking with clients about their plans, reviewing them. Often we'll look at the spreadsheets so that we don't just look at the legal language that was drafted, but also understand operationally how things are passing through. But you don't necessarily need us to do so. You saw the flow chart above. We certainly encourage you to use this opportunity to check across the board. We're going to talk in a second about the self-disclosure process just a little bit more in depth, and you may dig in and realize, well, it's not even this change that we have to address. We have to address we haven't been following these rules or we made mistakes. Well, as Gretchen noted earlier as a preview, there's a process that can help take care of that. You may also decide with legal counsel, with your own review, that we're going to make changes, but we think we were close, or we think we were right, we think we were compliant, but out of an abundance of caution, we're going to make changes. So now's a good time to do that. The rules have changed or are changing January 1st. Now's a good time to talk with your partners in physician groups, with your physician employees, say, hey, here's some of the things we want to do from a compliance perspective, and readily use this looming change. Look now, our experience, and I'm sure many of you on the phone have more of this than even Gretchen and I, is changing physician compensation plans, methodologies, calculations is not a one-week exercise. It takes time, it takes meetings, it takes, kind of a view of how to come together and make sure everybody is feeling positive about the change. And so we wouldn't leave this to December. We really think this is a fall project to kind of look and hopefully after your review, all you're going to do is confirm that A, you've been historically doing it appropriately, and B, you're still fine on a go-forward basis. But never want to just assume now's a good time. Act, take a look, and review.
So this slide kind of outlines the self-disclosure protocol. As Tim mentioned, you opening up these compensation structures certainly can, as often does when you turn over leaves, you find some stuff you didn't necessarily want to find when you take a look and open these documents. It is certainly our experience that physician groups try to do things in the right way and sometimes trip over these rules. They are very complicated, they are not intuitive, and as we've talked about, the intent doesn't matter. It is not uncommon when we are helping to diligence or review items where mistakes have been made, and that's okay. And that's why the self-referral disclosure protocol is in place, and why the difference in damages that we talked about at the beginning, which I'll show here, that's the purpose of the self-disclosure protocol, right? To enable folks to raise their hand to the government, absolve themselves of the liability associated with the mistake, pay a fine, refund some dollars, and then move on with comfort that this is not going to become a multi-million-dollar issue. So what is the self-disclosure protocol? It is a process by which you submit to CMS a self-disclosure. It's exactly what it is, saying, here's what we did, here's the mistake we made, or we think we made. You have to admit that you either have a violation or you believe you had a violation. You have to run some calculations, right? What was the value of the improper referrals based on the information or based on the violation? Because as we talked about at the beginning, every referral that is not, every financial relationship that is not protected by an exception is an improper referral. So you have to go through the process of looking at those DHS referrals, the dollars that came from Medicare for those referrals, and you have to go to the government and explain. It's not an easy process. It takes a long time. It takes years and years and years to resolve. Tim and I both have many of these disclosures that are pending and have been for 2, 3, 5, 7 years. But while that is very frustrating because you cannot wash your hands of it and be done with it and move on, it's always kind of looming out there and hanging out there. It does give you the comfort that no one's going to come in and play gotcha with those kinds of errors and expose the organization to much more liability there. Again, some additional information on the self-disclosure here. It is a process, and certainly your counsel can help you walk through those different components of it to make sure that the disclosure is done in the correct way. The other note here quickly is that if you don't do your diligence now and January 1st rolls around and you have one of the non-compliant compensation structures starting January 1st and you're listening to this webinar on May 15th, you might have a self-disclosure for that window of time where you hadn't made the change. So again, look at it, consider it, take the steps you need to get it cleaned up so that you are ready to roll January 1st.
So we're approaching the top of the hour. So what I'm going to just do on this 2-column slide, and then the next is note that this is not the only change in Stark World, as Gretchen put it. There was an advisory opinion this summer. There is a pending proposed rule right now that CMS put out on indirect compensation. And as I go to the next slide, I will invite you to send questions through the Q&A box because we can take maybe one or two depending on what comes in. There are also changes that were part of the massive for Stark. We geek out on this stuff, but the Stark law changes that came out last year that started in January this year. And again, as Gretchen noted, there is an article on our website, and I think also a presentation on the website taping kind of those changes so you can take a look. But today, if we quickly summarize before heading to any questions that came in, group practices, as Gretchen noted, have significantly more flexibility under the Stark law than other types of facilities, but they still cannot pay based on DHS referrals. That's ultimately what CMS is trying to stop here. They have very detailed production bonus and profit sharing rules. Whether your flow chart has a maple leaf on it or not, you have to keep it all in mind. And then when you get to profit sharing, you must aggregate it. You need to pool the pool before you start splitting it up. And that's what that flow chart kind of gets to, and certainly an opportunity for you to speak with counsel. You have until January to get any adopted revisions, and other things are happening in Stark World. CMS continues to review, revise, and consider industry stakeholders. Gretchen, as I flip to the questions and contact information slide so folks can see that and reach out, and I know our team will be getting the slides out to all the attendees in the days to come. Any last things you want to mention that maybe I missed kind of in that quick wrap up at the end?
No, I think that's right. And I think the one additional reminder that we didn't maybe highlight is the compensation rules also require that your formula be sent in advance of the referral. So you're not going to be in a position to be able to retroactively put in place a more compliant compensation formula. It has to be ready to go and in and voted and approved on or before January 1st. For all of those referrals that come in after that point in time to be protected. So again, now is the time. The weather's turning cold. Get it done, and we are certainly here to help if you have any questions.
Thank you all very much for joining us. We appreciate it and look forward to working with you throughout the balance of the year. With that, take care.